So Deputy Executive Officer for Planning and Performance, Jeff Henderson, is here, and he will give this presentation. Thank you.
So we'll begin with an overview of what we're going to cover today. And the graphic that's on the slide here to the right, which is also available in your staff report packets, outlines the Council's covered action certification and appeals process. It may look a bit complex. Well, part of why it seems complex is because it's purposefully unique. It's a unique process designed by the legislature and fleshed out by the Council to respond to unique Delta issues. And our goal today is to unpack the process a bit more so that we're all operating with a similar understanding of how it works. We'll be answering a few basic questions regarding what a covered action is, what a certification of consistency is, what an appeal is, what a hearing is, and what a decision is, and how they each work and work together. And we'll look forward to more detailed or nuanced questions in our discussion today. One thing to remember as we go is that the Council's process is inherently an appellate process. It's not an approval process. And for this and other reasons, it's important for Council members and staff to remain neutral toward projects that may come before us. Our review is really limited to the issues brought before us on appeal. So what is a covered action? Let's begin. It's important also to remember when the Delta Reform Act was passed in 2009, and similar to today, restoration projects were happening, conveyance projects were proposed, and Delta communities needed preservation and investment. What was maybe a little different was that parts of the Delta were urbanizing at an unprecedented pace on the tail end of the housing boom. That made achieving habitat, water supply, and Delta displace objectives all the more challenging. In passing the Delta Reform Act, the legislature intended the Council to develop, implement, and legally enforce a single unified blueprint to achieve the state's co-equal goals for the Delta, to restore the ecosystem, to improve water supply reliability, and to preserve the Delta as a place. That blueprint also needed to ensure that state and local agency actions in the Delta were consistent with the blueprint so that they didn't make achieving the co-equal goals more difficult. The Delta Plan became that blueprint, and it now includes regulations that state and local agencies must demonstrate that they're consistent with. The Council's review essentially applies to a subset of proposed actions by state or local agencies in the Delta that are covered by one or more of 14 Delta Plan policies, which are adopted as regulations. The agencies determine if their proposed action is covered, and if covered, they determine if that covered action is consistent with the regulatory policies. So what are the criteria for a project to be considered a covered action? They're spelled out in the Council's enabling legislation, Water Code Section 85057.5, and they're summarized here on the slide as a plan, program, or project defined in Public Resources Code 21065 that takes place in whole or in part within the Delta or the Sassoon Marsh, that's carried out, approved, or funded by a state or local public agency, that will have a significant impact on achieving one or both co-equal goals or implementing government-sponsored flood control programs, and that are covered by one or more Delta Plan regulatory policies. And there's, for reference, a table on the right side of the slide that lists each of the regulatory policies in the Delta Plan. I've highlighted two that we'll go into just as an example momentarily. Each of these regulatory policies describes what it covers, and then it states what such a covered action must do to be consistent with the Delta Plan. So each one has two parts, defines what types of actions are covered, and then defines the requirements that those covered actions need to achieve. For example, the Council has a regulatory policy that we refer to as ERP5. That covers a proposed action that has the reasonable probability of introducing or improving habitat conditions for non-native invasive species. Once it determines that what's covered, it requires that action to demonstrate how it's avoided or minimized the potential to establish or improve habitat for invasive non-native species, things like water hyacinth, nutria, or golden mussel. As another example, the Council has a regulatory policy referred to as DPP2 that covers a proposed action that involves the siting of water management facilities, ecosystem restoration, and flood management infrastructure. That policy requires that such an action demonstrate how it has cited the water management or ecosystem restoration project in a way that avoids or minimizes conflicts with existing or planned land uses. Okay, so what then is a certification of consistency? Simply put, it's a written statement of facts and findings that's offered by the agency that describes how its project is consistent with the Delta Plan policies that it's covered by. In the certification of consistency, the agency makes detailed findings about, first, again, the applicability of each regulatory policy to the action. And for each applicable policy, it makes findings about the consistency of that action with the requirements of that policy. Most of the certifications of consistency we've received to date have been submitted by the Department of Water Resources, local reclamation districts, flood control agencies, and cities and counties. Most have been submitted for ecosystem restoration projects or levee projects. So that takes us then to what is an appeal and who can file one. After an agency submits a written certification of consistency using the Council's online portal, which one can find at coveredactions.deltacouncil.ca.gov, that posting starts a 30-day review period. Within that period, any person may appeal the certification to the Council on the grounds that the covered action is inconsistent with one or more of the regulatory policies. And importantly, that as a result of that inconsistency, the action would have a significant adverse impact on achievement of the co-equal goals of one or both of the co-equal goals or implementation of a flood control program. Cannot stress this part enough. So I'll say it again a little more simply. An appeal must connect an alleged inconsistency with the Delta Plan to an adverse impact on the co-equal goals or a flood control program. If no one appeals a project, the covered action can proceed. And the Council's appeal requirements are spelled out in the California Code of Regulations, beginning at section 23 CCR 5020 et sec. So what happens after an appeal is filed? Well, communication protocols go into effect immediately. Council members and staff are subject to what are known as ex parte communication restrictions. This means generally that we don't talk with others outside the council about the covered action or the appeals outside of a public hearing. We also publish a notice of appeal within 5 days, letting the certifying agency, you as council members, the Delta Protection Commission, and the public know about the appeals and explaining how the process will work from there on. The certifying agency then files a copy of what's known as the record within 5 days to the council. The record's basically a collection of documents that the agency relies on in making its findings in the certification. After that, we publish a notice for a public hearing and request written briefing documents from the appellants, the certifying agency, and the Delta Protection Commission. Briefs are meant to tie the appeals arguments made and the certification itself to the record that's now available to the parties. So what is the Delta Protection Commission's role in an appeal? The Commission, as another Delta agency, has a role in the appeals proceedings. Section 5028 of our appeals procedures addresses the role. The Commission may submit written comments on issues raised by an appellant in an appeal and whether the certification of consistency is supported by substantial evidence in the record before the certifying agency. No new appeal arguments can be raised at this point. The Commission may also make an oral presentation to the Council regarding issues raised by an appellant in an appeal at the hearing, and the Council considers the comments and presentations submitted by the Commission as those of an expert agency in matters that may affect the unique cultural, recreational, and agricultural values of the Delta when preparing, considering, and adopting its findings. So what happens at a hearing? Usually a hearing is an agendized item at a council meeting, and it must happen within 60 days of the appeal. Council staff then presents the covered action, the certification, and the appeals to the council in the hearing. And then the certifying agency, the appellants, and the Delta Protection Commission appear before the council to present their case and/or address issues that are raised in the appeals. Again, at this time, no new issues can be raised. Council staff may provide questions for parties to focus on in advance of the hearing so that we can help to try to focus the hearing on the items that are still sort of outstanding in terms of consideration. What does the council consider in making its decision? It's important again to stress that this is not an independent review of the certification. Rather, it's a review that's limited to the issues that are raised on appeal. The council has appellate authority and oversight. We don't approve projects, we don't deny projects, we don't condition projects. Those projects are already approved by other agencies, and our role is, as framed by appeals, to determine if evidence in the record supports the agency's finding that the covered action is consistent with the Delta Plan. At all times, there's one question to ask and answer. Is there substantial evidence in the record that supports the agency's certification that the covered action is consistent with an applicable Delta Plan regulation? That's it boiled down. This is, at the end of the day, a deferential standard. The certification is presumed to be valid unless the lack of evidence says that it's not. Thus, it becomes the appellant's burden to prove that the answer to the one question, again, is there substantial evidence in the record that supports the agency's certification that the covered action is consistent with an applicable Delta Plan regulation? It's the appellant's burden to prove that the answer to that question is no. So what is a council decision? The decision is essentially a written statement with specific findings for each policy, and within each policy for each issue raised on appeal, one of three outcomes that we'll go over on the next slide. A majority vote of the voting membership of the council is required to approve a decision, and once approved by the council, a decision is subject to judicial review if it's challenged. What are the outcomes of a council decision? There are essentially three options. The Reform Act and the council's appeals provide options to dismiss the appeals if they don't identify an applicable issue or an appealable issue, if they don't provide required information, or if they're outside the council's jurisdiction. It also provides the option to deny appeals if evidence in the record supports the certification. And the third option is to remand the matter to the agency that filed the certification for reconsideration because the certification is not supported by evidence in the record. Some of our more complex appeals have involved all three types of findings. For example, on Lookout Slough, we dismissed some appeals, we denied some appeals, and we remanded some matters for reconsideration. What happens after the council's decision? If the council dismisses or denies all of the appeals, the covered action may proceed. If there's a remand, the covered action can't proceed until the council's findings are addressed in a revised certification and any further appeal issues are resolved. And the scope of certification and appeals in a revised certification would be limited to issues that are remanded by the council and/or changes to the covered action. So I stole a little bit of the by the numbers thunder here. So since 2013, we've had 58 certifications of consistency. 6 of those certifications have been appealed. 21 unique appeals have been filed across those 6 appealed certifications. And of the 6, 1 certification was remanded by the council. And as I stated earlier, most certifications, roughly 88% of them, have been for restoration or habitat improvement or levee-related projects to date. So hopefully we've untangled some of the steps in this seemingly complex process in a way that helps give us a similar understanding. And I've reposted the process diagram here and would be happy to engage with the council regarding any questions you may have about any part of the process. Thank you.
Thanks, Jeff. Yes, Councilmember Zingali.
Thanks, Jeff. That was a great refresher. Can you remind me how it's decided if an issue is a new issue and therefore inadmissible? What's the process for that and who decides?
In a recertification context,
Yeah.
it's basically the appealable issues in a recertification context are limited to those issues that were remanded by the council. So we look at an appeal and there's a number of issues and some are denied and some are dismissed. And then perhaps one or more is remanded. When that certification comes back to the council, the only things that are under consideration are those remanded issues and any changes to the project in between the two certifications if there have been. Essentially, once the council's made a decision, it can't reconsider those issues.
And it is just self-evident in all cases that it's when an issue is new or out of bounds, or is this something like Jorge, is somebody who sort of acts as the parliamentarian on an issue like that? Because, it just occurs to me there could be different views of whether something is new or not.
Yes, there could be the council could ultimately make a determination, because whichever way you slice it, if there's a debate over whether an issue is new or not, the approval would, the determination of that issue, even as a parliamentarian, if I give advice, would be determined by the council. But that being said, to just follow up on Jeff's point, when the council issues a decision and there's a remand, it's going to be very clear what they're remanding. So, for example, if the council were using some of the policies that Jeff referred to earlier as examples, if the council were to remand on WRP1, that would be any future, and then that agency recertified, the issues would be limited to what the council remanded with respect to WRP1. So there's going to be some level of clarity because the council is going to be very clear on what they're remanding if there were to be a remand.
The initial decision would make clear the issues that are still outstanding.
And so you guys don't anticipate any gray areas there where we would need to
not so long as we do a good job in the decision of making it clear. So that's why it's going to be very important that if there were to be a remand, that it's expressed very clearly as to the issues that are being remanded, so that there is no confusion.
Thank you, guys.
Thanks. Anyone else? Yes, Councilmember Burgess.
This is really good. I appreciate this presentation. I think it would be great to have a recording of this presentation on our website for folks to understand the whole process and, the limitations of what it is and all of that. On the list of certification, on the certification of consistency, they have to address all of those things on page 4 of 16, the Delta Plan policies, correct?
All of the policies that apply.
That
Again,
apply.
and each policy has two parts. One defines what it covers. The other defines what's required if it's covered.
And then those that appeal, they can use any of that list, basically, or do they have to? Can they appeal only on what the applicant is the applicant the right word?
Fair.
Okay, I'm trying to use the right language for folks. If the applicant addresses the Delta Plan policies but doesn't address one of them, can an appellant appeal on? And this is not planned questions. I'm trying to be a bridge for people to understand the process.
So the answer, if I understand it correctly, let me restate it so that we're
Okay.
We're clear. So you have a certifying agency. An agency submits a certification.
Right.
They make findings. So these policies apply. These policies don't apply. An appellant can come in and challenge all of that.
Okay.
So an appellant can come in and say, we disagree. We think this policy does apply.
And here's why.
And here's why. So,
Right.
and then that would be, our standard of review is always going to be substantial evidence on the record. So we would look to see whether the agency's decision that is inapplicable is supported by the record. or whether the appellants actually made the case that the agencies were incorrect in their their decision that it doesn't apply. But to be clear, I mean, that's why it's really important if people look through those policies, they kind of outline what it covers. So again, using WRP1, that covers an action that transfers, exports, or uses water in the delta. So that's going to be kind of a limited universe of activities that's covered by that specific policy. But each policy has a similar articulation of what it covers, and absolutely an appellant can contest that.
And so this commission is made up of 7 people, 4 people that are appointed by the governor, 1 that's appointed by the Senate, and 1 that's appointed by the Assembly. And then the chair of the Delta Protection Commission, which is how I'm serving on this commission. And you talked about the Delta Protection Commission and how they can take a position. So I'm gonna let Jorge and or Jeff kind of talk about the unique role that I play on top of being on the Board of Supervisors and a lot of other things in Contra Costa County. So just because I think this is such a great moment for people to understand what we do and who we are and why certain things happen, because I think going forward, people are going to have expectations of me to answer certain questions because of the different roles I play. And I have continually made it clear that I am neutral and that I have this role, but I would love for that to be kind of addressed.
Sure. So when the Delta Protection Commission has the role that Jeff fleshed out, they can come in and they can comment. Their comments are going to be limited to the issues that were raised by the appellants, unless the commission can also be an appellant itself. If they chose to, they could file an appeal.
And typically, or always, I am, as the chair of the Delta Protection Commission, when those discussions occur, I step out.
Yeah.
So I just want to make sure that people understand that I am not a part of the decision making of how the commission takes a position.
So traditionally, our DPC chair, will recuse themselves from any consideration of anything that's going to potentially come to us on an appeal, so they can maintain that neutrality. So yes, even though you have this role as chair, in maintaining that neutrality, that it wouldn't prevent you from participating in this.
And also sitting on the Board of Supervisors, I also take that that recusal as well. And all of us are asked specific questions about our interaction with Delta agencies, our own personal interests.
That's correct. So just like any other, as attorneys for the council, we are always very careful to make sure that we do appropriate conflicts checks to make sure that nobody is in a position to be improperly considering a matter. It can be a contract or more critically here, a decision like on an appeal.
Okay. I think that covers my questions. Thank you so much. And I do hope that we will have this on our website. I will want to share this. And I will say, when I first joined the Delta Stewardship Council and they showed this little chart, it made me really happy because it is really a helpful little chart. So I appreciate the effort to help people understand what we do and why we do it and how we do it.
And I would like to relay those thanks to our Office of Public Participation, who was very instrumental in putting that together.
I guess I'd like to sort of bring up that all of the Delta Plan policies and the description of them and then how they're being complied with are something that a submitting agency would have the opportunity to discuss ahead of time to fully understand what all that is, so that when they do submit something, they've been well informed by the staff at the council. So Jeff, do you want to kind of address that?
For that reason that we encourage agencies to take advantage of our early consultation process,
Right.
where we are able to consult with the agencies about the applicability, again, both parts, the applicability of the policies that determine whether the action is covered, and then once covered, how the action complies with the policy. More so, what are the requirements of the policy? And then we help guide the agency in making its findings. We don't make the findings, the agency makes the findings.
Got it. Thanks for clarifying that, explaining it. Does any other members have any questions for Jeff about this? Nope. Great presentation. I agree.
Thank you.
I know this was something that Council Member Miller and I were both really keen on having an explainer available. Unfortunately, she couldn't be here today, but I know that we're going to make sure it's widely available for everyone, including our council members who couldn't be here today to hear it, because I think it's just helpful reminders for us, and it helps answer a lot of questions that we get when we're out talking to different members of the public or our elected officials about what we do here at the council and how our appeals process actually works. So super helpful.